In the last video, we talked about people trying to secure legal representation when they don't have sufficient financial resources and the use of contingency fees to accomplish that purpose. People are often under the impression that they can somehow prompt the state or the federal government to bring criminal charges against their adversaries and in that way save themselves the time, hassle, and money of bringing litigation against their adversaries themselves. Now, the problem with this approach is that a private attorney cannot bring criminal charges. Only federal attorneys, known as United States attorneys or assistant United States attorneys, can charge individuals with crimes. Or on the state level, criminal charges are usually filed by county attorneys. Here in Minnesota, they're called county attorneys. In some other jurisdictions, they may be called district attorneys. On the federal level, you have 93 U.S. attorneys scattered throughout the country. There is one U.S. attorney for each United States district court. Here in Minnesota, there is only one federal district, so we have one United States attorney. And the number of assistant U.S. attorneys varies from office to office. The U.S. attorney is also in charge of the U.S. Marshal Service and the FBI for that district, and are essentially the detectives that are investigating criminal charges on behalf of the United States Attorney's Office. Now, on the state level, they usually have a similar structure that parallels the federal system. Here in Minnesota, we have an agency called the BCA, the Bureau of Criminal Apprehension, the state equivalent of the FBI. BCA will assist any county attorney in the state in investigating crimes that occur within their county. Another entity that may have prosecutorial authority is the state's attorney general. An attorney general is essentially the lawyer for the state, and in many states, an attorney general does have the authority to bring criminal charges on behalf of the state. So unless you're a United States attorney or an assistant United States attorney or a county attorney or in the attorney general's office of a given state, you do not have the authority to file criminal charges against anyone. Criminal charges are initiated by filing what's called an indictment. In a criminal action, the prosecuting attorneys can deprive an individual of their liberty. They can put them in jail, they can put them in prison. Only the state can do that. And when I say state, I mean government, federal or state government. Now, on the private side, when one individual sues another individual, that's called civil litigation. And the only thing that can result from civil litigation is a monetary award, which we as attorneys call a judgment. The party that initiates the action, the party that was injured by the wrongdoing, is generally called the plaintiff. The party who allegedly committed the wrongful conduct and who owes damages to the victim or the plaintiff is known as the defendant. So at the end of the day in civil litigation, the most that can happen in the best case scenario is that a jury is going to award to you, the plaintiff, a certain dollar figure that will compensate you for the injuries that you have sustained. And the idea in civil litigation is to simply put the individual back into the position that they would have been in but for the defendant's wrongful conduct. In some civil contexts, you do have the right for punitive damages or damages that are designed to punish the defendant, but those situations are fairly rare. On the criminal side, when the claim is successful, a jury will find the defendant guilty, and then a judge normally imposes a sentence, and these sentences are regulated to a great extent by sentencing guidelines on both the federal and state levels. So those are some considerations when you're thinking about the differences between criminal and civil litigation. Essentially, just remember that as a private party, you can't initiate criminal litigation yourself. Anybody has the right to report any type of wrongdoing to the FBI or to the U.S. Attorney's Office or to your county attorney or to the local police. If your neighbor's dog is barking too much, you can report it to law enforcement. The other thing that you have to realize is once you report a crime to law enforcement, it's kind of out of your hands. Law enforcement has all sorts of considerations that they will weigh before they decide to prosecute any particular criminal activity. Prosecuting authorities are not concerned with activities that injure one person or a very select group of people, unless it's a very serious crime, obviously murder or robbery or rape. Most of the crimes that are reported to me are not of that level. They are rather financial crimes. Many times, prosecuting authorities will not consider prosecuting a financial crime that injures only one victim or injures only a handful of victims. Although many people think that the government's resources are unlimited in this country, the government's resources are very limited. They can't afford to prosecute every crime that's committed or every crime that's reported to them. And so when they're looking at the allocation of their resources, they will often focus on those financial crimes that injure the largest number of people, figuring that if you are the single victim of a scheme to defraud, or if you and a handful of other people are victimized by a scheme to defraud, you can get together and hire your own attorney to bring a civil claim and seek redress on the civil side. Prosecutors are very reluctant to use taxpayer funds to redress a dispute that is essentially between two people and essentially only involves money. Once you report it to the FBI, or once you report it to a U.S. attorney, or once you report it to a county attorney, the ball is in their court, and you don't have much control over the way that ball is going to bounce. It will be up to the prosecutor's discretion to decide whether they will charge someone, whether they will further investigate the crime that has been reported, or whether they will simply let it drop. But that doesn't mean that you shouldn't report crimes, because a lot of times in these prosecutorial offices or investigatory offices, you may have one crime reported, and initially that crime doesn't seem like it's significant or something that would warrant the attention of the prosecuting authority. But then if you have more and more victims reporting the same crime, or that the same individuals are involved in the same types of activity, and there is a greater injury than was initially indicated by the first reports, that can greatly alter the situation and may justify a prosecutor directing their attention to that problem. So it's always worthwhile, if you think you've been injured by a crime, to report it. You just have to be aware that once it's reported, it's not under your control. Once you've reported it, it's up to the prosecutor to decide whether to prosecute it or whether to simply let it go. There's no easy way around the issue of financing litigation, unless you're a very wealthy individual who does not see money as an object. But for normal people, our justice system is oftentimes inaccessible because of the financial investment that's required to litigate a case. Those economic considerations are certainly at the forefront of any lawyer's mind when they're talking to a potential client. With today's law lesson, I'm Jeff Gorell.